These are the answers for the questions on the website regarding a university, Penn State, that is asking personal medical questions of its faculty for the purposes of perhaps reducing future medical costs and aggravating medical conditions. So the idea is that if you tell us about yourself, this is what the insurance company is saying, we have data that can help you to live a healthier life. So they've been accumulating data about the faculty in hopes that they can review that data, and the analytics will help them to help the faculty to improve their lifestyle and their health condition. So the first question is, what types of questions are the university asking the faculty to answer? Basically, the question that seems to bother people the most are questions such as, are you planning to have a child in the future? Do you have stress in the workplace? Are you having difficulty with your supervisor? These questions, I think the faculty are concerned about if they were to get in the hands of the university, what implications would that have on their job, on tenure, etc. 2, does the employer have a valid reason for requesting the information? The article would lead you to believe that the employer truly wants the insurance company to use the data to figure out ways for the faculty to improve their lives and to reduce medical costs. That seems to be the sole benefit of requesting and analyzing this data. 3, what assurances are given by the employer and the insurance company regarding the collection of this data? The head of the insurance company has stated unequivocally that the information will be kept private and that it will not be released to the university. 4, what constitutional claims might the faculty bring against the state university? Well, as a state or a governmental entity, the question is whether or not the university is invading the faculty members' right to privacy. Would a reasonable person find having to turn these questions over to a governmental entity to be an invasion of privacy, a violation of the Fourth Amendment? 5, if this matter goes to arbitration or court, what will be the issues before the judge or arbitrator? Number 1 will be what we just mentioned, the question of whether or not a governmental entity has invaded the right of privacy of its employees. Number 2 might be a contractual issue because of the fact that the employer provides this employment insurance for health based on some contractual basis. Does this violate that contract? Or does it in fact violate the contract not to assist the employer in reducing costs? The reality of this case, whether we call it a contractual claim, or we call it a tort claim, or we call it a constitutional claim, it all comes down to the same issue here in the United States. How are employers going to be able to continue to provide health care if they can't find out how to lessen the impact of poor lifestyle, how to better educate employees so that health care costs are reduced? 6, things to consider, private versus public employer. It's important for you to see here that while many private employers, and that means folks that are not funded by the government, General Motors, Ford, Steelcase, Amway, 3M, etc., they have more rights as employers to restrict the activities of their employees. Public employers, like the government, like state-funded schools, like police and fire, there's more of a concern that the government is invading their privacy. So that will be the first thing that you have to note in these cases. Second is the scope of the questions. How much are they asking these employees to divulge? And how can they ensure that if in fact they have the right, the employer or the insurance company has the right to request this information, how can they ensure that that data won't be breached and that that information will be divulged? And if in fact it is, who will be responsible for divulging that information? The next question I think that everyone has if they're an attorney is, there's something called e-discovery, and that happens prior to a lawsuit, where anything that's in data format, electronic format, can be discovered if the court determines or the arbitrator determines that it is reasonably related to the case. In this situation, if there is a court case involving the employee and the employer, the university, will the court be disallowed from requiring that any information gathered by the insurance company can be turned over to the court or the arbitrator or the employer or the employee? Will this information, this data that has been acquired, will it be off bounds, out of bounds, for anybody to use in a court of law or an arbitration case? And then finally, the reasonable expectation of privacy. Clearly, the university is trying to make it so that their healthcare costs are reduced and they have a healthier workforce. But what is the reasonable expectation of privacy by an employee? Do they have to divulge all this information about their personal lives and about their medical histories if in fact they want to make use of medical care? And if medical care is shown to be reduced in cost substantially by divulging this information, acquiring the data, and using it to assist the population that's being insured, is that enough to override any concerns of privacy? These are the questions that will occur with this case. Thank you very much.